All right, class. My name is Michaela Plattenberg, and today we're going to talk about the competence to testify. All right, so who is competent to testify? According to Myers Rule 601, anyone can testify unless overcome by sufficient evidence. And two things that are important to point out about the competence to testify is that it's that where it differentiates between other competencies is that other competencies concern only the defendant. Testimonial competence may arise in connection with any person who might testify, whether that be a witness or a defendant. Another difference is that the competence to testify comes about in civil trials as well as criminal trials, but it is particularly in criminal cases where it is alleged that a child has been abused. Back in the 1970s, most states presumed that children under a certain age were incompetent to testify. However, today we have Myers Rule 601 that deems anyone competent to testify unless they are overcome by sufficient evidence. Now, when it comes to the sufficient evidence and the age, and not even necessarily age, but when it comes to the sufficient evidence, it is important that the individual who has observed or who will be testifying to said event has these five capacities. The five capacities are the ability to observe the event, to remember the event, to communicate that memory, to decipher between a truth and a lie, and lastly, the ability to understand the obligation to tell the truth in court. When we're talking about observing in observation, we're talking about the ability to have seen or heard something. If a person is going to testify to something that they have observed, it is specifically something that they have seen or something that they have heard. Now, a defense attorney or a prosecutor that will be, cross-examining said witness that has said to have observed something that happened would want to ask the questions: does this child have a visual or hearing deficit? And that would deem them incompetent to have observed said event that they are testifying that they have observed. Here I have hyperlinked a video that talks about the case of Bynum v. State, where a victim of sexual assault, she has cerebral palsy, and she was able to testify about what happened to her using different methods of communication. She clearly had certain deficits that some would deem her incompetent to testify about what happened. However, according to Bynum v. State, she was deemed competent to testify and was able to use different types of ways and different type of methods to communicate what happened to her on the stand. This video also talks about mental and moral competencies, and it goes into depth a little more about the topic. And I will drop the link in the chat for you guys to view that as well. All right, the second competency is memory. It is important whenever we are evaluating witnesses to understand if they can remember the event accurately, especially in connection with children. The timeline of the event or when the event happened is very important. If we are talking about something that happened months or years prior, and our court date is set for next month, it is important that when we are evaluating this individual, when we are evaluating this child, we have to see, is this person competent to have remembered what happened? When we're talking about memory, We're talking about two types of memory, which is recognition memory and recall memory. The observer, the evaluator, would want to ask questions like, does this person recognize that person? Or do you recognize this person? Could you point this could you point out this person for me? Could you describe this person for me? And when we're talking about describing, that is recall memory. You ask an individual, you ask a child to describe an event, to describe a person, to describe a place, that which is the most stable type of memory is the recall memory. Now, when we're talking about memory, we also have to think about suggestibility, and that goes hand in hand with the timeline of when the event occurred. So, suggestibility comes about when there are third parties who are influencing a change in an individual's memory. So, say a child witnessed something 2 months ago, 3 months ago, and since that time frame, they have talked to a number of police officers. They've talked to psychologists about what's happened, and you know, sometimes individuals suggest things. However, said suggestibility does not make a person incompetent to serve as a witness. According to Myers, people are not rendered incompetent because of suggestibility. All right. The next capacity is communication. And communication goes hand in hand with comprehension as well. In the case of Bynum v. State, as I mentioned before, the child with cerebral palsy had a hard time communicating, so they had nonverbal ways to testify and different things, different methods to facilitate the process of testifying. It is also important that children comprehend the meaning of sexual terms and behavior, even though they use language differently. When helping a child testify, there's often been ways to comfort the child and resort to different type of ways to get a child to testify to what happened to them. Even if a child doesn't comprehend what exactly happened was wrong, they can still communicate that the incident did happen. It's also important for individuals to understand the difference between a truth and a lie. Now, a person with a mental illness or a child needs to understand the difference between a truth or a lie. So it is important for the evaluator to ask the person that they're evaluating to explain the meaning of truth. Because once you get on the stand and you go under oath, it is important that you know that you are, swearing to tell the truth before the court and before God. And it has also been proven that children are not more prone to lie than adults, which also, goes into saying that it does not render a child incompetent if they do not understand the difference between a truth and a lie. Even though it is important, it still does not deem them incompetent because children are not more prone to lie than adults. So what makes an individual incompetent to testify? People who are incapable of remembering or reporting may not testify, which what we talked about in the 5 capacities. It is important for an individual to be able to remember what happened and to report what happened. That goes into the timeline of the event and the relevance of the event. Did said person remember what happened? Is said person able to report what happened. Every person is competent to be a witness. However, that does not mean that every witness is credible. Now, witness credibility can come up in court, and it allows the testimony, it allows the attorneys to attack their credibility. So attorneys are allowed to bring forth questions about said person's reputation. Say a person have a reputation of not telling the truth, and the other party is using them as a witness. The defense attorney or the prosecutor can use that to take an attack at their credibility. Now, a judge will still let a person who does not have the best credibility testify, because that does not render them incompetent. So what does actually make a person incompetent to testify? If, according to Myers Rule 601 and 608, every person is competent to be a witness. When evaluating a witness, evaluation should focus on the 4 capacities: observation, memory, communication, and the ability to tell between a truth and a lie. Now, courts will evaluate. However, they are reluctant to do it on privacy grounds. Courts tend to only want to evaluate a witness if it is relevant. In civil cases, they will evaluate witnesses under good cause, if it is good cause, which is more than a possibility of relevant evidence. And in criminal cases, defendants usually request the evaluation. So it's a touchy subject because judges and courts do not want to invade the privacy of the witness. However, if need be done, if need be evaluated, it will happen. So an overview over what we discussed today is that according to Rule 601, anyone can testify. Testimonial competence may arise in connection with any person who might testify. And also, courts proceed with caution when evaluating witnesses for testimonial purposes. All right, so we have a discussion question, and it is, if a witness is not credible, does that deem them incompetent to testify? I hope you guys enjoyed the lesson and actually took something from it. And here is my reference page. And that concludes my presentation. Thank you.